Welcome everybody to Rights on the Farm, an update on estoppel, covenants and rights over rural land. This is an update and some informal commentary on recent developments in property law which have particular relevance to the agricultural sector. Your speakers today will be me, Joshua Dubin, and Andy Nicklin, both of us from 3PB's Property and Estates team. Andy has particular connections with East Anglia and its rural property sector. The format for today is as follows. First, I'll be discussing the important case of Guest and Guest in the Supreme Court, and then I'll hand you over to Andy, who'll be looking at recent cases in the High Court and Upper Tribunal on restrictive covenants protecting agricultural land. Each speaker will talk for about 20 to 25 minutes on their topic. There'll be a question and answer session at the end once both speakers have finished their talks. The presentations that accompany our talks will be emailed to you after the event for you to keep and cherish. There's a bit of Zoom housekeeping. At the bottoms of your screens, you will have a Q&A button. Please use that button at the bottom center to post your questions to us, which we'll answer at the end. We're not going to publish the questions on the screen. We're keeping them anonymous for reasons of confidentiality and data protection, which we found from experience is the best way to proceed. There is also a chat function. We don't bar you from using it, but please don't post your questions and answers there. So now I will talk to you about Guest and Guest, the Supreme Court's 27th case of 2022, the right remedy for a proprietary wrong. So that case was published on the 19th of October last year. It was heard nearly a year earlier in December 2021. The facts of the case relate to Tump Farm near Chepstow, a dairy farm. And the principal farmers, the parents, were David and Josephine, and Andrew, their eldest son, had worked on the farm since he was 16 for wages which since 1996 had not kept up with the Agricultural Wages Board's minimum rates. And Andrew had some siblings, Jan and Ross, and in 2012, there was a renewal of Dayhouse Farm's tenancy. Now, Dayhouse Farm had become available in 2007, and David and Josephine took it and integrated it into the Tump Farm business. And so its renewal enabled a revision of the family business structures. So Ross and his family moved to Dayhouse Farm, and because Ross and Andrew couldn't work together, the parents entered into two separate partnerships with their sons, 50% to each son and 50% to the parents of each partnership. It's important to know that the parents made various wills, but never showed them to the children. In 2014, they cut Andrew out of their wills, except for his occupation of granary cottage. The relationship had been somewhat difficult, and in 2015, the partnership between Andrew and his parents was dissolved after negotiations broke down. He didn't accept an offer of a farm business tenancy of Tump Farm. He didn't think that was commercially viable, and his parents served him with a notice to quit. So Andrew left and became senior herdsman at a farm in Tewkesbury with a house included in his employment package. By the time the case came to the Supreme Court, at Tump Farm, the dairy herd had been sold, but his parents remained at the farm and Ross remained at Dayhouse Farm, and the parents wished to continue farming Tump Farm under the Dayhouse partnership. On figures that were in front of the Supreme Court, Andrew's differential in gross earnings between 1990 and the trial amounted to £247,000 odd. And if one added in low drawings in the partnership, he might have earned something in the region of £267,000 more if he'd worked elsewhere. And interest on those earnings at 2% amounted to over £342,000 over that period at the date of handing down of judgment. So if one were to value the detriment to Andrew of the promise made to him that effectively, one day, son, all this will be yours, rounding the result to avoid a spurious impression of precision, as Justice Leggett put it, it would amount to approximately £610,000. So if you were going to monetize the detriment that Andrew suffered because his parents didn't keep their promise to him to let him carry on farming Tump Farm after they died, that would be £610,000. Now, this decision's a bit of a Beauty and the Beast. It's beautifully written and it's a beast of a judgment because it's so long and it's in two parts. And as is often the case, the dissenting part is longer than the main part. So the first part is Justice Briggs's paragraphs 1 to 106, giving the leading judgment in which he concludes the appropriate thing to do in a proprietary estoppel case is to compensate the expectation loss. Lord Leggett's secondary judgment from 107 to 282 was to remedy the detriment. In other words, the purpose is to stop a detriment occurring to the person who was expecting to take, in this case, the farm. Now, it is a secondary judgment, I've said. Is it technically a dissenting judgment? Yes, it is. But it deserves consideration in its own right for a number of important reasons. First, it has an analysis of the development of proprietary estoppel. It really gets under the bonnet, takes everything apart and puts it back together again to work out why we have a cause of action in proprietary estoppel and what that means for working out what the remedy it should be. But secondly, he also explains in some detail how one would value a detriment. And I'll come back to this difference between fulfilling the expectation and valuing the detriment in a minute. When it comes to proprietary estoppel, there is something that we all think we know, and that is that when you're giving a remedy for it, what we give is the minimum equity to do justice. And that comes from comments by Lord Justice Scarman in Crab and Arran District Council. I've highlighted there the expression, the minimum equity to do justice. And he's there talking about two questions, the extent of the equity that's raised by the estoppel and the relief needed to satisfy it. So he talks about the minimum equity to do justice to the plaintiff as a right either to one kind of remedy or as another. And that's been translated into a suggestion that the court separately chooses the values the expectation and the detriment, and then chooses whichever is the cheaper to give to the promissor as their remedy. Justice Briggs was extremely forthright in saying that this was not what was meant. His dictum was not minimum equity, but minimum equity to do justice, remedying the unconscionability identified in the promissor's repudiation of his promise. And he did later comment that Lord Justice Scarman would have been very surprised to find that people were saying, put a price on the detriment, and that's the minimum equity you give to the claimant. But because of that misunderstanding, over the last 25 years, a lively controversy has arisen. The problem of principle in what remedy you grant, and that lively controversy is a phrase from Lord Justice Lewison in Davis and Davis about the essential aim of the exercise of the judicial discretion in giving an award. So one line of authority was the purpose is to give effect to the claimant's expectation unless it would be disproportionate to do so. And the other, that the aim of the discretion is to protect the claimant's reliance on the promise. In other words, compensated for such detriment as she's suffered. So those are the two lines of authority. The Supreme Court held, resolving the controversy as it had been asked to do by the parties, that the purpose of the remedy was to hold the promissor to his promise. What does this mean in terms of remedy? The court's looking to compensate for the loss flowing from the repudiation of the expectation. So that's quite a high level of abstraction. What does it mean in practice? I should mention, in terms of looking through guest and guest, I've done it for you so you don't have to. There was a significant review of the authorities. First of all, Justice Briggs went through those authorities that support the proposition that it's all about enforcement of the expectation fulfillment. In other words, holding the promisor to the promise. I promise to give you the farm, remedy, transfer the farm to the claimant. So those are all the authorities that he went through and examined in some detail each of the judgments and what they said about the principle. When it came to valuing the detriment, it was a much longer list. But you'll see it speeds up a bit from the 1990s. And basically what these cases are ones where you might say the court has valued the reliance loss. In other words, I had to go and work elsewhere. I could have earned more. This is the value of my earning elsewhere. That's therefore the remedy I should get. So there are those two lines of authority. Do you fulfill the promise or do you value the detriment and choose the cheaper of the options? There was also a third stream of principle that had crept into proprietary estoppel remedies, and that was proportionality. That comes from Robert Walker, Lord Justice Robert Walker as he was then. The essence of the doctrine is to do what is necessary to avoid an unconscionable result, and a disproportionate remedy cannot be the right way of going about that. So Justice Briggs said you wouldn't disagree with that at all, but it's not the case that until then proportionality had been in it, but after this the seed that was sown by that has grown and proportionality has a place. So where do we get to? The court should firmly reject the theory that the aim of the remedy for proprietary estoppel is detriment-based. It forms no part of the law of England. And he gives the key reasons for that at paragraphs 52 and 53. Because what we're looking for in equity is a flexible conscience-based discretion to produce justice, not mechanically monetarizing the detriment and the expectation and then seeing which one's lower. So what are the applicable principles? If you're going to take something away, you're going to want to know when you have a client coming to you, how am I going to work out what they might get if they can prove that there's a remedy? And if there's any part of the judgment you read, it's that core discussion at paragraphs 61 to 82, in which Justice Briggs distills his consideration into something approaching a pragmatic overview of the principles and how they apply to the cases generally. Some important background factors. The second, first, the relevant time. You're looking to see what the values might have been at the time the promise is repudiated or someone attempts to repudiate it, although events up to and including the date of trial may remain relevant for valuation purposes if you get that far. But the key point is that there is a spectrum of promissory estoppel cases. So at one end, there's the understanding little short of contract in which the expectation and the detriment have been clearly defined, where a full expectation-based remedy would usually be appropriate. In other words, this is sometimes called the quasi-contractual promise. If you work on the farm until I die, you will inherit all of the farm. So at that point, if the farmer dies and the child has worked on the farm all his life, both sides have fulfilled their parts of the promise, and the child would therefore have a claim against the father's estate, which would likely be fulfilled by ordering the farm to be transferred to the son together with its business. But at the other end of the spectrum, you have a case where the expectation is genuine but not clear, where the fulfillment of the highest expression of it may only be a starting point. So if we take something at the other extreme, outside the family scenario, you would have, for instance, a young man goes to look after an elderly lady in the last years of her life, expecting to care for her for some considerable time. And she says, you can have my most valuable ring. And she dies after only 2 months. So the young man's not given up very much. And the most valuable ring turns out to be worth £10 million. Was his 2 months of detriment proportionate to the £10 million of the ring? No. But that's one where the promise was of a very long period of work and the reliance on it very short. So those are some examples that may help one understand the spectrum of cases that we're looking at. So Justice Briggs says there are two stages. The first is there unconscionability? If you look at all the facts, is the promisor's repudiation of his promise in light of the detrimental reliance upon it unconscionable at all? So, for example, changes of circumstance for both the parties can render what might have been a solid claim of unconscionability into one that isn't. So even if the court gets as far as finding there was a promise and reliance and then a repudiation, it may be that the repudiation is not unconscionable. So, for example, if in Guest and Guest, Andrew's parents had suddenly become very unwell and needed to sell the farm in order to pay care costs, or the business had been very badly affected by some particular problems and they'd had to sell up and move on, then it would not necessarily have been unconscionable for them not to give Andrew his share of the farm and the farm business. So if you've still got unconscionability, you come to what Justice Briggs called stage 2, which I've chosen to lump together under the heading fashioning the remedy. So what are you going to give to the claimant? The starting point, because we're looking at fulfilling the expectation, is to assume the remedy is to hold the promisor to the promise. But there are some things that are important factors to bear in mind, which may take you further and further away from a straightforward giving what was promised. So has repudiation occurred after the date of fulfillment or before? So in the case of Guest and Guest, the promise was to inherit. But here, clearly, David and Josephine were very much alive, still farming, and the break with the parents had come a long time before the inheritance was due. So that means that you might not be looking necessarily to give the full extent of the promise. But it depends also on all the other factors, including what period is left before fulfillment. Another important point is, has the property been sold in whole or in part? So if the promise in any context would be to give a house or a piece of land, but the promisor no longer has it, then necessarily you're going to be looking at something in the way of a money claim, what the Supreme Court called a proxy for the promise. You should also look at the period during which the detrimental reliance had occurred. As I've suggested before, if you've worked your whole life on a farm at low wages, you're much more likely to find that that is recognised by forcing the promisor to make good on the promise and give the whole farm. But if you were supposed to work there until your parents died, and after 10 years you got fed up and moved on, you can't necessarily expect, assuming it's still unconscionable, to get the whole farm. Something else might be required to do justice. Another important factor is the clean break, to avoid cohabitation. So this would be, for instance, where there are warring parties in a family dispute, but also, moving away from the matrimonial home, what happens if the parties on a farm can no longer work together, do not want to, have been unable to? Do you need to find a solution which, while not necessarily being the whole of the promise given over to the claimant, still has to reflect it, while still making sure that the parties don't have to maintain a relationship with each other? And a discount for accelerated receipt. So assume that you need a clean break. You can't pass on the whole of the property promised, whether that's a farm or a farm business or something else. So it's going to end up being money. But if the money would be the full value of the farm, but it's coming now and not in 15 or 20 years when the parents die, you've got to discount it for accelerated receipt. And that is something that equity here can borrow from the common law in order to work out what kind of discount that should be. In Guest and Guest, as you'll see, it turned out to be, amongst other things, the value of a life interest in the farm for the parents, which would diminish its value overall, and not merely be a life interest which the court could grant. Now, there isn't a stage 3 in Justice Briggs's analysis, but it helps, I think, if we think of it as a stage 3, checking the justice of the remedy. And this is where valuing the detriment may have some role. The question we have to ask is the proposed remedy out of all proportion to the detriment? Where the detriment is specific and short-lived, and in particular shorter than the parties are likely to have contemplated, then evaluation of the detriment is likely to serve a useful purpose. So in the example I gave earlier of the young man who inherits a valuable ring or its monetary value, he's not going to inherit the whole of the monetary value because the detriment was only 2 months at low wages looking after the old lady, and certainly not as long as they had contemplated when she made the promise, and £10 million, or even £1 million perhaps, might be out of proportion. So you would look at, for example, equivalent care costs that he provided to her over the period. And the difference between what he did provide and what he could have earned providing it might be the value of the claim. But no computational approach to those I would have earned something else elsewhere cases if you can avoid it. The courts didn't like the idea of going into a highly technical, wage-specific or otherwise mathematical calculation of your detrimental reliance. So do we end up with minimum equity to do justice to the claimant? The question you've got to ask, and one that I think I'd be putting in my skeleton arguments, would be an overall assessment of the justice of the remedy. And at paragraph 80, Justice Briggs gives us the yardstick. Whether, if the promisor was to confer that proposed remedy that the court has fashioned upon the promisee, he would be acting unconscionably. So, if you are proposing that the court should fulfill a remedy which is conscionable, which does as well in all the circumstances as the original promise, that will be the minimum equity to do justice. There are some additional principles. The first is election. If you have 2 options, 2 kinds of remedy that the court is favouring, then it would be for the person who's having to pay up to make the election. The persons against whom the equity is asserted should be the ones to elect between the 2 options. And blame. A lot of these cases are strongly disputed matters of family argument, but the courts, both Justice Leggett and Justice Briggs, were very keen on the idea that you shouldn't try to apportion blame or spend very much time cross-examining on it or dealing with it in your submissions. That kind of conduct that the relatives will complain of will only be relevant in 2 circumstances, they say. Particularly oppressive conduct by the defendant that increases the detriment beyond the norm, or in an extreme case only where the claimant's own misconduct could exempt the defendant from the responsibility of preventing the claimant from suffering detriment by relying on the promise. Not always easy to think about what circumstances those might be, and I think the court simply said, don't talk about blame. It doesn't help the judge work out what the remedy should be. Important for advisors, offers and costs. There are some very strong steers that you should try and fashion your own remedy for the alleged unconscionability and make a genuine and reasonable alternative arrangement or offer of amends to the other side, because that's likely to provide not only costs protection, but the avoidance of litigation altogether. A strong steer then to make sure that you've considered in settlement something that's reasonable. And there are in the judgment some interesting remarks, particularly from Mr. Justice Leggett, about appeals and the kinds of things you would expect to see in a promissory estoppel case that the judge asks herself and then answers. Have they, in particular, given reasons for the figures they choose in the remedy they've given? And do they remember to ask themselves the proper question about minimum equity to do justice? So the result in this case, it was a case at the quasi-contractual end of the spectrum, which needed to take into account the siblings' interests. They had expectations on the inheritance. It needed a clean break. Andrew already living and working away. he could retain the 50% of the business already under his partnership that the judge had awarded, and 40% of the farm was appropriate, but only once the parents died. So there were two alternatives. Andrew could have a reversionary interest under a trust of the farm, the parents having a life interest in the meantime, and you could make arrangements if there was a period between their retirement and their death or leaving the farm where Andrew could be the manager, or a sale of the farm now, tax inefficient as it would be, so Andrew has to share the burden of that tax inefficiency, but discount it to take account of the fact that this was supposed to be an inheritance, but it's now become a lump sum early. And the parents were to elect which option. Why are so many proprietary estoppel cases agricultural? There was a review of the cases in the High Court that had been tried in the previous 4 years before judgment. 17 of them out of 21 were agricultural. I think it's because, first of all, these are family businesses and they're family disputes. And secondly, it may have something to do with record keeping, that farmers are already keeping so many different kinds of records, and partnership records, and company records, and meetings of resolutions. But perhaps the long-term planning is only ever implicit in all those records. And it might be worth, when there are agreements about the very long-term future, that they get written down as well. What can be done to prevent disputes? That's always a great question. Advising our clients to keep good records and to make sure that their expectations are known to the other side before there's a breakup of relationships would be useful. What can be done to settle disputes as early as possible? As the Supreme Court suggests, try to find a reasonable alternative. So questions on this topic we'll answer after Andy's talk, and I'm now happy to hand over to Andy, and thank you for your patience.
Thank you. So I'm going to talk now about restrictive covenants over rural land. And unlike Joshua's talk, which really started by looking at a seminal case in Guest, I'm looking at really some practical examples in terms of the High Court, two decisions from the High Court as to the application and enforcement of restrictive covenants over rural land, which may assist. And secondly, to look at the upper tribunal's first instance jurisdiction to look at modification and discharge under Section 84 of the Law of Property Act. Before I do, just by way of introduction, some of the reasons for restrictive covenants being in place to protect agricultural land, it is common to see agricultural purposes only as part of the wording in a covenant of that type. That, of course, could have commercial reasons in terms of agricultural work carried out on the land, but it could also be for other reasons to do with what has been seen in some of the cases I'm going to discuss regarding a rural view and that need to limit urbanisation in an area which has its identity and character as typically agricultural. To that end, it's therefore typical to see these to control the character and amenity of the land. But the first case I'm going to talk about is an example of a restrictive covenant that required consent and a case that's discussed how that should be approached. This is the case of Davis, Gilbert and Gocher. This was a trial before Her Honour Judge Claire Jackson sitting in the Business and Property Courts. It's a large area of rural land known as the Gilbert Estate in the South Downs National Park in a village known as East Dean. The claimant was the owner and estate manager of this large area of land. To the north, there had been two parcels of land previously sold off, and those parcels of land had to the south and east of them some land that was ripe for development, for building dwellings on them. And the restriction was not to erect a building or wall without consent, not to be unreasonably withheld. Some works had begun in breach, but ultimately planning had been obtained, and the defendants then, in wishing to carry on with this work, applied to the claimant, the estate owner, for consent to build. The consent was refused in a letter that set out two reasons that you can see on the screen. The first, that it would have a detrimental impact on the amenity value of the estate. That caused problems in this case because you'll note it says the estate. There was a concession at trial in this case where it was accepted by the claimant, the covenantee, that not all of the estate had the benefit of the covenant. And the second refusal was that it could threaten the future use and commercial value of neighbouring land. And you can see there the types of considerations that were taken into account. It's ready for us to be able to see that in a certain situation where a landowner knows they have a consent-based restriction, that they may feel quite safe in thinking, well, my neighbour can't build on that land because I have to give permission, and I'm not going to give permission. But of course, this case shows us that there's so much more to it than that, and how the parties need to approach it, ideally, as ever, in taking advice early. What the claimant sought was an injunction to restrain that work from carrying on and a declaration that the consent hadn't been unreasonably withheld. And obviously, the defendant wanted a declaration to the opposite effect. What the judge said was that in a consent case, the primary finding is what was the reason or the reasons for refusal that were influencing the mind of the covenantee at that time. And the way that the court goes about looking at that is to apply the Wednesbury unreasonable test. And that really comes from a case, a Supreme Court case called Braganza, which the citation for that will be available shortly on the chat room. That was a case that concerned a contract, and where a party to a contract had a discretion that they needed to exercise, then the Wednesbury principles would apply as to how that should be exercised. Briefly, by way of assistance to everyone, what the Wednesbury principles require is that, firstly, that it shouldn't be said that it's so unreasonable a decision that no reasonable decision maker could have reached it. And secondly, where the process had failed to exclude extraneous considerations or had failed to take into account all relevant ones, then it would fail that test. And so what we have here is that test, having in Braganza been applied in a contractual setting, applying here in this area of land law. And that is the guiding principle by which one looks at, firstly, the process, and secondly, the reason that's given for the refusal of consent. What that means in practice is, well, you can't really refuse consent in order to achieve some collateral purpose that the landowner might have, something to do with the wider area of where they're based, perhaps, or they can't seek an uncovenanted advantage, which, for the first reason in this case, was to protect the entirety of the estate, not all of which, as I've said, had the benefit of the restriction. It also, of course, it involves looking very carefully at what considerations have been relied on. And when advising, that means looking at the difference between what are the considerations and what are the reasons that are given in order to identify, firstly, the process and then the outcome. What the judge said was that not all factors that might be in the covenantee's mind would influence if, for example, it's clear that they've considered something and attached zero weight to it. But of course, that comes down to the clarity of the reasons that are communicated to the covenantor, because if it appears they've taken into account something and not made clear what weight they've attached to it, they could end up in some difficulty. What the judge also said is that where they have relied on some valid, good reasons that mean that it's reasonable, but there's also other reasons there that might be what were described as bad reasons, it doesn't vitiate the decision, providing you're clear as to how the good reasons were arrived at and that they weren't reliant or dependent on the bad reasons. What that means in this case is that the second reason that was advanced, which was to do with the economic value of the neighbouring land, was found to be a reasonable basis for refusal. because that concerned only land with the benefit of the covenant. And that concerned a reasonable concern on the part of the covenantee, the claimant, as to the economic value of that area as a result of the development. So in this case, the first reason was effectively refused, but the second was accepted as a reasonable basis for refusing consent. And on that basis, the claim for the declaration and the injunction succeeded, and the covenant held firm. That's an interesting case ultimately for how we look at cases involving consent. It's something where if you're advising later on down the line after the decision has been made, you're going to want to look very closely at really a structural analysis of how a client has approached a decision like that. Likewise, if you're on the other side, to separate out what their considerations were and what ultimately the reasons are that they're relying on relative to the facts and the area of land that has the benefit. Obviously, if you're advising someone early on, then you have the advantage at that stage of ensuring that the reasons are properly communicated and well explained. The next case I'm going to come on to is the case of Mills and Estate of Partridge. And now this is really to do with agricultural activity on land and diversification. This is a large area of land in Staffordshire. The claimant originally owned all of that land. There's about 100 acres with a farm and a house, a track running through it, leading to two areas that had been sold off. One was a nursery and a field that effectively were owned and operated by the defendants. They had various business interests on the field, but the nursery had grown over a period of time and scaled up to the point where by 2017, the defendants had opened a tea room on the site of the nursery, which was the source of this dispute. The right of way over the track running through the claimant's land, as you can see there, limited the use of the track for the purposes in connection with the use of the land as agricultural land only. And the restrictive covenant concerned for the nursery agricultural land and no other purpose whatsoever, and in similar terms in relation to the field with some exceptions. The concern here was about the development of the nursery, but principally the diversification of that business into non-agricultural activity. The defendant has said that what it was doing with the tea room and the nature of that type of trade was within agricultural use. The starting point that was made clear in the case was that you're looking at the meaning at the time of the conveyance. And of course, with the term agriculture, covenantees have the benefit there of the statutory definitions that exist in originally there, the Agriculture Act and also the Town and Country Planning Acts. And that's very much based on agriculture as an activity when one looks at the strict wording. The reference that was made by the judge to activities that were incidental to or take their colour or purpose from and are in that sense ancillary to agriculture was found to be an activity that would be within that definition. Likewise, if something was peripheral, perhaps moving outside of the exact scope of agriculture, but it was carried out in a small or minimal way and incidental, that wouldn't undermine the restriction. So there's some flex there for a business that's carrying on agriculture where perhaps it broadens out the nature of its activities. But again, it's a matter of scale and degree. What the court considered is one needs to look at the overall view. It can't be too concerned with how the landowner has labelled these activities and what it thinks they are. One needs to look at the activity that's taking place on the land. Is it retail? There's an interesting discussion in that case about the difference between a garden centre, which might be principally buying in products to then sell them at retail, compared to a business that is growing produce on the land and then selling it in the way that one would expect of a nursery. Ultimately, in this case, the tea room was found to be a separate trade with a turnover that well exceeded incidental use. The evidence showed that there was a restaurant menu, an entertainment license. It was able to host all sorts of different types of events under that license. It was also able to serve alcohol, and it could be open at times when the nursery itself was closed, notwithstanding that it was part of that land. That moved into the non-agricultural activity, and on that basis, it exceeded the user of the easement and was a breach of the covenant. So what that perhaps shows us is that the integrity of a clearly worded covenant remains intact, particularly where you have the advantage of some statutory definitions that may add support. But ultimately, what practitioners need to do when they're faced with a case like that is look in the context of the whole undertaking as what the scale of any diversification is and how that might affect the definition when it comes to the term agriculture. I'm going to move on now to Section 84 of the Law of Property Act, and that is, of course, the jurisdiction to discharge or modify restrictive covenants. That is dealt with by the Upper Tribunal Lands Chamber in its first instance jurisdiction, and there's a right of appeal from those decisions to the Court of Appeal and then the Supreme Court. The jurisdictional grounds, many practitioners will be familiar with these, are very broadly that if one says that the restriction is obsolete, or that it would impede some reasonable user of the land for public or private purposes, or that the parties agree, or that it would not injure persons entitled to the restriction, then the applicant can make out one of the jurisdictional grounds for modification or discharge. At that stage, if that's proved, the tribunal then has to exercise its discretion as to whether to grant relief, something which, in one of the cases I'm coming on to, is made very clear. Under the Gateway subsection AA, which is a very common application regarding development of land, where it's said to be impeding a reasonable user, the question is whether or not that secures for the beneficiary any practical benefits of substantial value or advantage, or is contrary to the public interest, and money is an adequate compensation. And I'm going to look at some of those cases in a moment. The first is Collins and Howell, and that concerns an area in Devon of a property known as Higher Norris Farm. Next to it was a 9-acre piece of land known as New Park Stables that had previously been within the title of Higher Norris Farm. And the owner of the stables obtained planning permission to construct a menage and landscaping and access way in order to develop the land, which was strictly rural land, for the purposes of training and exercising horses in what's described as an all-weather environment. Mr. and Mrs. Howells, the respondents, continued to live at High Norris Farm next door. They were the original covenantee, and the covenant restricted the use of the Collins field to grazing sheep and horses and arable uses of all types, with only stables being built by the boundaries. And it was found that the purpose of that restriction was to preserve the rural and agricultural identity of the farm. And so this is quite important because it's the type of restriction that means a great deal to somebody, particularly that is in a dwelling that has hived off some of its land with the benefit of a covenant, where really its primary concern is the rural view and the tranquility of the area. And the key issue for the tribunal there was to decide whether or not that conferred on the Howells some practical benefit of substantial value and advantage. It ultimately was unusual in the sense that this didn't involve typical building of dwellings or something of that type of scale. And one might even think that the equestrian feature was something that was in keeping with a rural area. But nevertheless, it clearly interfered with the farm, its privacy and tranquility. What they found was that the levels of this land as it was laid out meant that the menage would be imposing, even if it was screened, affecting that rural view. And it was said that it was a material circumstance, something that was taken into account, that the restriction provides a benefit which Mr. and Mrs. Howell had bargained for when they sold off the land and obtained the covenant in the first place. Bear in mind that it was only 20 years ago that they obtained that covenant, and therefore modification would diminish the rural setting which underlies the identity of the farm. And on that basis, the application failed because it was found to be of substantial value and advantage. So that is a case that perhaps helps show that where somebody has a more recent covenant protecting what is ultimately a rural view, there is a basis to be able to protect that on the facts where that is the benefit that was originally secured by the covenant. It would be an interesting question to think about what would be the case if that had been a consent covenant and consent had been refused in those circumstances. I'm going to move on now to Millstrand Developments and TAP. Now, this is a very different type of case involving a restriction of a similar type regarding agriculture. This was a site in Worcestershire. The company held an option and applied with the consent of the freeholders, where it had outline planning consent for 5 dwellings. And what we have here is an area of rural land just to the south of really a village with a lot of different houses on it. And Mr. Tapp, I think it was, had the benefit of a restriction which restricted buildings except for agricultural buildings or buildings of an agricultural nature. So it's different from the Collins case because it did allow for building, but it was envisaged that that would be to carry on agricultural work on the land. And it was ground AA and C relied on in those circumstances for modification. What the evidence actually showed was that really the agricultural land to the south of the respondent's property, where he was currently having his rural view, was described as scrubby wasteland, that it had long laid fallow. There'd been some very limited arable farming on it, but it didn't really have much prospect of future agricultural use. And there's also an issue with the viability of access to this site for future agricultural trade and work. And in those circumstances, there was a reasonable proposal to build these houses. What it was going to do was take the respondent who was on the edge of the village around this countryside to a position where he was no longer on the edge of the village and he was surrounded by houses. But this went to that question of substantial. And in this case, it was found that the value of that advantage wasn't substantial, doubtless taking into account the background of the land as I've described it. The agriculture was now largely redundant. And of course, it was agricultural buildings that were allowed and weren't restricted. It was 50 years ago when the covenant was made. And it was thought that that was at a time when there was actual real agricultural activity taking place in this village, which wasn't the case now. And in those circumstances, it tipped the other way. Money was adequate compensation. And in those circumstances, the modification was allowed. So I'm going to move on now to the final case that's gone through the upper tribunal. Actually, this one does take us up to the Supreme Court. It may well be a case that practitioners are familiar with, but there's an update as to how it's come back to the upper tribunal this year. This case concerns Millgate Development Limited and also a housing association called Housing Solutions and Alexander Devine Children's Cancer Trust. This is an area just outside Maidenhead. I understand that the Supreme Court decision is the first one on Section 84, and so it's useful for practitioners to have it as a bookmark for the future. The land itself was previously all owned by the Smith family. It was a very large area of agricultural land. And in 1972, Mr. Smith's father, who'd owned the land at that time, sold a triangle of that land off to a company that already owned a bit of land to the north. And that company created a car park with that triangle. There was a covenant protecting Mr. Smith's land in respect of that triangle to not build on it and to only use it as an open space for parking vehicles, i.e. to carry it on as a car park. After Mr. Smith died, his son, Mr. Smith, inherited the land, and he gifted about 6 acres to the north next to this car park to a hospice trust in order for there to be a hospice built for the benefit of terminally ill children, with views out across the agricultural land. And what happened was that Millgate then purchased the car park and built something in the order of around 23 houses, affordable homes, on that site. They built it on the unburdened land, which was the land that the company had previously owned, and also the triangle that had come from Mr. Smith in the 1970s. They built that before they dealt with the issue of the covenant. And it was only after they'd been completed that they then applied to the upper tribunal. The upper tribunal released or modified the restriction in those circumstances and awarded some compensation. The land was then transferred to the Housing Solutions, and at that point, permission or an application for permission to appeal was lodged by the Hospice Trust. It then went through the Court of Appeal and the Supreme Court. And what the Supreme Court clarified was that one needs to deal firstly with the jurisdictional stage as to the grounds, and then be very mindful that there's separately a discretion that should be exercised by the tribunal after that. In this case, there was a real issue regarding what was described as a cynical breach, because there was essentially a fait accompli that had come by from the company having built these properties in circumstances where they were then able to satisfy the contrary to public interest aspect of the legislative provisions. And that's because it would clearly be contrary to the public interest to impede them from being able to use these affordable homes, which would otherwise go to waste. And the Supreme Court took issue with the fact that what they'd effectively been able to do was transform their prospects of success on the public interest ground by carrying out the work before applying to the tribunal. They were very clear to say that in terms of a jurisdictional ground, the issues of conduct don't come into it. You either meet the ground or you don't. But on the discretionary ground, it was a highly relevant factor. In those circumstances, the Supreme Court remade the decision and refused the application, putting the housing association, which had now acquired these properties, back into a position where it was in breach of covenant. The update comes this year, in January of this year, where Housing Solutions went back to the upper tribunal to apply to, again, modify the covenants. And that modification came with the agreement of the Hospice Trust this time, after matters had been settled between them. But Mr. Smith's son, who owns all of the land, the rural land to the south, continued to object. And what's interesting is he ran a number of arguments, including that it was an abusive process and that there wasn't a basis to be able to effectively relitigate the issue. But what the upper tribunal found is that this was a different situation now, that the upper tribunal had was able to take account of the fact that the Hospice Trust agreed with the fact there should be a discharge, and that Mr. Smith himself did not have land that connected directly to the applicant land. And in those circumstances, when they looked at it again, they thought they were making a new decision, that they weren't dealing with any relitigation. And on that basis, they allowed the modification. It's an interesting case looking at its whole story, because it does show that there are bases in which a developer may be able to go back to the drawing board and look at how it might deal with matters differently and potentially come and make a further application. It's also important because it's quite common for more than one landowner to have the benefit of a restrictive covenant. Where there is some agreement with a beneficiary of a restrictive covenant, particularly one that's important, in this case, the Hospice Trust, because they have the neighbouring land to the development, that may cut through. And it may well mean that in those circumstances, the objections are of lesser weight. So there are a number of factors there that can be taken into account, particularly when looking at agricultural land, particularly as to the economic viability and amenity of the land when one is looking at how it's developed and changed over time. This is perhaps quite a unique case, but it's one nonetheless that, including the dicta that comes from the Supreme Court, is helpful for practitioners to be aware of when dealing with restrictive covenants going forward. I come then to some brief concluding thoughts. what some of these cases show is that agricultural protection in the form of covenants can be enforced on clear wording where the activity and purpose is still clearly relevant and that there's still economic value in it. And I think that's really the key thing that cuts through from this variety of different cases. There's also, of course, the issue of now knowing that with the issue of consent, covenantees need to apply very carefully the way in which they deal with considerations and reasons. And that's likely to be the case when this issue crops up in various forms of land law. It was only yesterday I noticed that the Renters Reform Bill is suggesting that there may be, if it becomes law, implied into an assured tenancy, a right to request consent to keep a pet, and that request and that consent not to be unreasonably refused. And one can see how similar principles may well be applicable in those types of situations in other areas. We've very much enjoyed, on behalf of 3PB, presenting these issues and hope to see you again soon at another event. Thank you and good afternoon.